Right.
My name's Peter Phillips, and I'm the director of the ADR Skills Program in New York Law School.
Yeah, I'll show you a photo.
And on behalf of the school and my colleagues, I welcome you
Was that the
to
CPR
the
meeting?
10th, is that right?
And
The 10th annual presentation on cutting-edge topics in commercial arbitration. In my role as the director of this program, there are, among many fruits and virtues and pleasures, there are two that annually stand out, and one is the symposium that we hold every January on diversity in our field, diversity in ADR. And the other is the annual program that we hold in April on cutting-edge issues in commercial arbitration. And I think it has to be said that the reason why I at least consider these to be such highlights is because they're both opportunities to work with Jeff Zaino of the American Arbitration Association. He's a tremendously gratifying professional colleague. The AAA CDR has been generous and loyal in its support of New York Law School's activities in many different ways, but I think mainly because he's just a mensch and he's just a fun guy to work with. So with that as an introduction, Jeff Zaino.
Thank you, Peter. As always, it's so great collaborating with New York Law School. And I want to thank the Dean and New York Law School in addition to you, Peter. It's so great. I'm proud to say, like you said, Peter, it's our 10th program. And we have a lot of people online today. We have not a lot in the audience, but thank you for coming in the audience. But we have 178 people registered online and about 30 in person. So it's going to be a good program. This is the Stephen C. Bennett annual program, cutting edge issues in commercial arbitration. Before we get the program going, since the passing of our friend in December of 2019, Stephen Bennett, who was an original member of our cast here, we named the program after him. And since 2020, he was on this panel. Oh, he was on this panel for 3 years. Okay, for 3 years. We always do a brief tribute to Peter and a moment of silence. He was a wonderful friend to all of us in the community. He's not been forgotten. And Jen Lupo, a good friend of his, has agreed to do a few words about him, and then we'll do a moment of silence and get the program started. So, Jen, we'll turn it over to you first.
Thanks, Jeff.
If everyone could talk into the microphones, please. Thanks.
Steve Bennett was not only my friend, he was my mentor. He was my co-conspirator. He was a generally good, to use Peter's term, mensch. He was a kind, generous, intelligent man, and he was the ultimate and consummate professional. I learned from him, as many of us on this panel have, many good things and ethical things in the practice of arbitration. But I also learned a lot of good things from him about being a good human. I miss him every day, and I know that he's looking down on us and smiling and smiling. And perhaps he's telling a joke or two.
Thank you, Jen. If we can do a moment of silence for Steve. Great, thank you. I always ask every year, who are the original members of the cast? Raise your hand, please. Got a couple. All right, 3 of it. Okay, excellent. Okay, so we have 7 terrific panelists, as we do every single year, that are going to discuss 3 cutting-edge issues. They are AAA ICDR arbitrators and friends. Starting to my right, we have Richard Mattiaccio, Chartered Arbitrator. We have Dana MacGrath, MacGrath Arbitration. David Singer, SingerADR Neutral Services. Their topic tonight is Emerging New Approaches to the Preliminary Conference, Initial Case Management Conference. They'll be talking about that first. Then we have Jen Lupo, of Lupo Law, Arbitration and Mediation, and Leslie Berkoff of Moritt, Hock, and Hamroff. They're going to discuss AI practices for the arbitrator. And then finally, we have Richard Silberberg of Silberberg Dispute Resolution and Steve Skulnik of Thomson Reuters. They're going to talk about the conundrum of arbitral jurisdiction and arbitrability. Okay, so with that said, I will turn it over to our first group. Richard?
So we thought that we would return to an old topic and discuss different approaches that have been evolving with respect to the preliminary conference and PO1, the first procedural order. David will begin our discussion by talking about the conference itself and the tribunal conference that precedes it.
Okay, well, thank you, and thank you all for being here. The reason we picked the preliminary management conference is because it is often an underrated component of the arbitration process. In reality, the preliminary conference is really critical, perhaps as critical as any other component aside from the evidentiary hearing itself, perhaps, and the writing of the award. It sets the stage for the entire arbitration process. And hopefully, if done well, it anticipates problems that often emerge, that may emerge in the course of the process. So it's important to take it seriously. It's important to be prepared for it, both as counsel and as the neutral, and to discuss all issues that may be on the minds of counsel or the parties if they participate, to anticipate problems that may be on the horizon, and then to schedule from soup to nuts, nuts being the actual evidentiary hearing, the entire arbitration. So it starts at the beginning, and we thought we would add, even before the preliminary conference, that it is the three of our recommendation that when a tribunal is assembled, particularly if the three arbitrators don't know each other, that you get to know each other, that you get together, hopefully in person, if you live in the same metropolitan area or otherwise, get together, get to know each other, develop some rapport with each other. You can also use that as an opportunity to discuss certain issues, some of which we're going to touch on, about approaches to arbitration, including the preliminary conference, that may differ among arbitrators. But we recommend that as a good idea to get things started, to develop a rapport, to get the arbitrators to know each other, so you're not just starting off completely fresh at the conference. Now, as far as the preliminary conference itself, and that we have a consensus on this as well, we recommend that it be done by video conference, not by telephone conference, which is really how it was done for probably most of our career. And in some respects, in some contexts, that's still the default. But I and we think that it really is more effective to get to know each other, to get a sense of counsel, for them to get a sense of the arbitrators, to do it by video conference, to see each other, to see each other's reactions. It's much more effective to do it that way.
David, do you ever do it in person? Or have you?
Rarely I have, but it's really, often not everybody is local. And it's typically not worth it, at least in my view, to make the trip to get everybody together in person. And I think, back when it was telephonic, we occasionally did it in person, but really video conferencing is very effective. So it can be done, but I haven't done it in memory. But it's a good question. It certainly can be done that way. The next thing is scheduling. As I mentioned, a critical part of the preliminary conference is to set up a schedule from that day going forward. And the question is, who prepares the schedule? Should counsel prepare it in advance of the conference and have something circulated in advance to work from or to be the presumptive schedule? Should it be done during the course of your conference when you're all on the video conference together and working it out with your various calendars in front of you? Or should you have a discussion with the arbitrator giving insight and some direction and then tasking counsel to go off on their own and confer and work out a schedule themselves to then be sent to the arbitrators for approval or tweaking? So on this, there's no one way to go. I personally do the middle ground. I like to do it when we're all on the conference together. Everyone who's important is either there or represented. We all have our schedules with us, and we're able to map out the entire scenario, which usually takes a half hour, give or take. The problem I have, and I've had it done all three ways that I've just described, but the problem I sometimes have with counsel doing the schedule in advance is that you can get a schedule that is really unworkable and not at all what you were hoping to receive. And you spend then a lot of time undoing and explaining why you're undoing what has already been done and then creating the schedule anew. If you have very sophisticated counsel who knows what they want, they're experienced, sometimes it works out. And I've had that circumstance where they come up with a schedule and it's beautiful and it does save time and it is efficient. But often you may not have sophisticated counsel or experienced counsel in arbitration. You may have counsel who are not working that well together, not collaborating that well together, may not like each other. And so it makes it very difficult for them to do it. And usually the work product then reveals itself. So those are the things I wanted to start out with. If anyone wants to comment a different view, I've indicated my preference on scheduling, or we could take it to the next
I
topic.
might add something on scheduling, which I don't think is so different from what you're saying, but if you're not going to invite counsel to try to work together and propose something jointly, or if for whatever reason, it just makes better sense to address it for the first time at the preliminary conference, I tend to send bullets of the topics that I want counsel to think about, even if they're not necessarily going to confer and reach some sort of agreement or quasi-agreement on, think about, witness statements, think about, things in arbitration parlance, so that when they come to the conference and we start talking about the schedule, they've already got sort of a roadmap of the issues that we'll talk about.
Right. So I think that the trend is toward customizing this approach to the parties. And arbitrators, I think, can't help but get a sense of how sophisticated in arbitration the parties are simply by reading the pleadings. Sometimes you get pleadings that are written for arbitration, and sometimes you get them that look like they're written for a federal judge. And those are two different things very often. So you get a sense of how sophisticated, they can be very sophisticated in litigation and not be very sophisticated in arbitration. And that may lead the arbitrator, it certainly leads me, to take more of a lead in shaping the schedule than letting the parties do it. Because you can end up with a schedule that is not very arbitration friendly, that looks more like what you would see in a pretrial order. So you get a sense of the parties from their pleadings. My approach generally is to let the parties know, and I think this is a fairly common thing, judging by my experience on tribunals, three arbitrator tribunals lately, which is to point the parties to, in the case of a AAA case, to the pre-hearing checklist, the P2 checklist that appears in the commercial rules. And it can also be used in other cases. I use it in international cases, and I think I've seen other people do it as well. As the topics that at the very least they should be prepared to discuss at the preliminary conference, so they know what it is they should be thinking about beforehand. And also encourage them to have a meet and confer to see if they can come to some general agreement on some of those terms. And I think that's very helpful. There are times when if the case is very international, it would be a different checklist, perhaps, if it's a very complicated case. But I found that checklist is very good to use in most cases. One size does not fit all, but if that happens to fit most cases, I think. So I would send that out and ask the parties to meet and confer about it and discuss it with their clients. One thing I always do, and I've seen other people do this fairly regularly, is let the parties know that we're going to set evidentiary hearing dates at the preliminary hearing. So they should speak with their clients, with their key witnesses, and be prepared to commit to different sets of dates depending on when other people are available.
Well, Richard, how often are the clients there? Not very often, is that correct?
I think I've seen more in-house counsel participation than in recent years than in the past.
Is that because of COVID? Because I noticed a difference during the pandemic. More people were showing up on Zoom. They had a little more time on their hands, but since we've gone back to in-person, probably not as much, or not in person.
Yeah, I think
like the regular kind of.
I think it really depends on how sophisticated the clients are. I think and how engaged in-house counsel are. I'd like to see in-house counsel there, because particularly if I think that what's being proposed in terms of discovery in particular, or motions practice, is not proportional. So if the arbitrator gets an opportunity to say with in-house counsel present that she's a little concerned about the time and the expense, and in-house counsel hears that, it might resonate more with in-house counsel than with outside counsel.
Richard, just a quick comment, if I may, and I think our panelists would agree with this. In deciding how you're going to customize the request to the parties in advance of the preliminary hearing, I think we all recommend that you confer with the case manager, assuming it's a provider-administered case, and let the case manager know what you're doing, because otherwise the case manager may by default send out his or her own template. And I think we've all seen those templates, and they contain things like fill in the blank of how many oral depositions you would like to take. And you have to then spend a good part of the preliminary hearing walking back the choices that have been made by counsel on that template. So
Right.
I would recommend that you speak to the case manager and head that off if you want to.
So what you should have in the materials are a few different approaches to PO1. One is that template that sometimes gets sent by case managers that are clearly designed for a certain type of case, which is a very domestic case and a relatively simple case. Then I put in the materials by what I call my kitchen sink form, which doesn't necessarily all get addressed. Sometimes I break it up into 2 or 3 different procedural orders, because it also gets into the conduct of the hearing, whether witnesses are going to be allowed to be present in the room before they testify, and all of those things that come up in a hearing. Because very often you have parties who don't know what to expect. So I find that sending it out and having them think about those issues, even if you don't address it all in the first order, can be helpful, because then they can start thinking about what sort of process they want. But absolutely, I always try to head off that form, at least for the sorts of cases that I think most of us are seeing.
Do you think the rule, that what's in the rules, you referenced the rules, there's a laundry list in there. Do you think that's okay? Or is it's a little different than the form that Rich is talking about?
Yeah, Rich is talking about a form that would be filled in when you're doing a procedural order, number 1, right? And sometimes you do it, my understanding is some people do it, just fill it in while they're having the conference. And that's different from the checklist, which is in the commercial rules. The P2 checklist are the issues that should be addressed at a minimum at the preliminary hearing. And that's a good checklist. I think you can add to it. Some issues are not going to be relevant, but it's a very good starting place.
We're in the process of updating our commercial rules this year, actually. So any suggestions from this esteemed panel would be great.
One suggestion might be that form that we've discussed, which I think most of us don't use.
Yep.
And when it's filled out by counsel, we're not so happy to receive it. And that may not make sense to be the default, but only to use in very simple cases and not in large complex cases, or, of that nature.
Sure.
And so it gets sent out. We don't know why or if it's going to be filled out. So it adds some uncertainty. And so I would just as soon not have that, quite honestly.
Steve, you got a comment?
Yeah, I mean, Jeff, to your question, the rules are great.
Yeah.
In fact, they all say that it won't be depositions. And in fact, even the large commercial cases that says, absent extraordinary circumstances. So why the case managers are sending out a form saying how many depositions we decide want is a mystery to us arbitrators. Something for you to talk about over lunch with your colleagues, I think.
Absolutely.
Yes,
No, I
right.
appreciate that feedback. I like the feedback, guys.
And then another piece of feedback that I would add.
I gotta start taking notes.
Is one more, to start taking your notes, is oftentimes it creates conflict amongst the council. Because we can ask our case managers what their feeling is in regard of how the council are working together with them, but we don't know, and the case manager oftentimes doesn't know. And sometimes we inadvertently create a conflict where we don't need to have a conflict
Sure.
going into the preliminary hearing.
Well, if you look at the rules, my favorite is the international rules because it says depositions are just not appropriate in international cases. It's not my favorite because I think that should always be the way to handle a case, but it's my favorite in terms of being the most explicit as to what the expectations should be. But there are a lot of international cases that get handled under the commercial rules because of the way that the arbitration clauses have been written, because the parties choose it when the case is actually filed. I think the filing fees are higher for international cases.
They are.
That may have something to do with the preference for commercial rules. And then the commercial rules are just silent about depositions. The rule talks about document discovery. Part of this process, and I think the preliminary hearing is really important, and I don't think it should be one and done necessarily. I don't think the expectation should be that in every case, you go to the preliminary hearing, you come out with a procedural order number one, and you're done. It may take two or three sessions with the parties. They may have very differing expectations. It's supposed to be their process. You can help, as the arbitrator, help them shape it, and you can try to lead them in a certain direction. But it has to be their process, and it has to meet their expectations. And I think the arbitrator, one of the issues that I think remains unresolved is how much power do arbitrators really have when the parties have agreed that they want the case to proceed in a particular way that the arbitrator or the tribunal doesn't agree with as being proportional or being the way it's done in arbitration. My own view is if the parties are in agreement that they're going to take 20 depositions in $1 million dispute, you have that conversation with them and you try to get them off that position. But in the end, it's their process. And I think this is a subject of debate. I think there are a lot of people who feel that, it's more important for us to be, as arbitrators, to be muscular, as the expression used to be at the AAA, muscular arbitrators, which always, as a phrase, intimidated me. But
How many years ago was that? That was like
That was-
15, 20 years ago?
it's about 20 years ago.
20
Yeah,
years ago,
right.
I thought. Yeah.
And I have to say, getting back to a prior point about that David made about whether or not we do in-person preliminary hearings. When I started this practice, personally, the default was that the preliminary hearing was in person, and then it became the default was by telephone, and I remember people being very upset about that at the time because the telephone just doesn't work, especially if you have many parties in council. So this is an evolving process. But I think one of the key issues that has not been resolved is just how much power the arbitrators have. And I think the providers are walking a bit of a tightrope because they want the parties to be satisfied by the process, but they want a process that has integrity and has certain characteristics at the same time. So achieving that balance is, I think, one of the challenges we have in a lot of cases. especially the complex cases. And the rules very often are silent on these questions. So I think the trend is much more toward trying to make parties do it the arbitration way. And not sure that's right in terms of.
I think it's our first chance as arbitrators to meet counsel and maybe the clients. And I find sometimes, as much as we are here to talk about procedure, and we try to talk about procedure at that first conference, there's a lot of substance that's coming to us from the parties, that sometimes you have to say, wait a second, like this is a procedural conference. But the procedure is tied to the substance of the case. Will they need a lot of documents? Will they, be doing how many witness statements? Because we're doing witness statements and not depositions. But in order to sort of advocate for their procedural position, sometimes counsel will be really, talking a lot about the merits. And that's helpful on one level for the arbitrators to actually hear sort of the story from them, rather than just be reading it. But I think it's important to keep it to process and procedure and keep that as narrow as possible, except to inform the kind of process that they need. I don't know if I'm the only one who seems to get, an opening, if possible, at the first procedural conference.
Not. I know. And I've had it where we were talking about conflict. I think you mentioned it. And sometimes they feel the need. And I think there's a balance. It's a balance between, do you need to understand the case? Because sometimes you can't understand what they're asking for based upon the demand. You may not have been a fulsome demand or anything like that. So there is a balance. And then there's a point at which they're getting in the weeds and they're maybe engaging in even ad hominem attacks, and they think they're arguing their case before you. And there's that pivot point where I'm pulling it back in counsel. That I want to understand what the dispute is about. I understand you have a disagreement, but I don't want advocacy. I want informed, factual statements as clean as you can, because I think they're figuring they're going to win you over in this first procedural conference, and you're just going to be completely biased for the rest of the case. And it doesn't happen all the time, but when it does, I think it's so important to peel it back. And if I can add one thing, a lot of times, and I'm, on these cases, they get set up still as a telephone conference, and I am trying on a lot of them, even if I send it out, I want Zoom. I can't, it's oftentimes hard to tell who's speaking. If there's multiple people speaking, they speak over each other. When you can see them, you control it so much better. And quite frankly, for some of us, sometimes we're the only woman on the phone and there's 8 guys. I can't figure out who anybody is at that point. But regardless, I think it goes better. And I think people are more civilized if you have to look them in the eye and they have to look you in the eye. I think it retains better control. That's just my view.
And Leslie, you make sure they turn on the cameras? No cameras off, is that correct?
No cameras off. No, I want to see who is on the phone.
Yeah, exactly.
We had hearings today on something, and it went so much better. There were 8 lawyers on there. It would have been very difficult to parse who's who, and just for efficiency. But I do believe, and it's not reflective of today's conference, that sometimes they will behave better, more civilized. You're less likely. It's easy to shout into a phone.
I think those are excellent points. I agree with that. And I just want to pick up on something that Richard said before, because I think another critical part of the preliminary hearing is you're really setting a tone for the rest of the arbitration process. And, there is this tension, I think, that he referenced between, it's the parties' process. They, ultimately, if they agree, they should be allowed to do what they want. On the other hand, you want to maintain efficiencies and keep the arbitration moving efficiently and forward. And, I may come a little bit more on, running a tight ship, putting emphasis on running a tight ship, making clear that the dates and deadlines that are being set are really kind of invalid unless there's really good cause to change the evidentiary hearing date or certain other dates that are critical. But also when it comes to, and the example is given with regard to depositions, I want to take 20 depositions. We want to take 20 depositions. I mean, I'll push back on that and say, well, if you want to take, do you really need it? Explore whether you really need it. Rarely do they need it. But then I'll put a cap. Let's agree then on the number of total hours, and you can use them as you wish. You can do 2, 10, but in the aggregate, it won't exceed X. And that is a way to maintain discipline also, that no matter how many you want to take, you have to work within a defined number of hours. And I don't prevent them from doing more, saying you can't do it, but come back to me if you feel you need more time. And I've probably done this 50 to 100 times, and the number of times they've come back to me and requested more time is 0.
Right.
Never happens.
Yeah.
And has never
Yeah.
happened.
There's another approach that's at least one person at this table uses, which is with respect to depositions, is
I know what you're talking about.
is to say, you want to have depositions, go ahead and have depositions. Just don't tell me about it, because it's consensual, and I'm not going to order them. I'm not going to referee them. If you have disputes, to the extent the parties agree, go ahead and do it, but I don't need to hear about it. I think that's a fairly unusual approach, but it's not inconsistent with the rules. Certainly, it may not be consistent with the parties' expectations, but on the other hand, if people know that the only way they're going to get deposition testimony is if it's consensual, then they may be less aggressive with one another in conducting the depositions.
Yeah.
So it's a solution.
I was just going to add one other thing, and sometimes depending on the case, I'm not adverse to sort of staging the preliminary hearing order. So it may be an inflection point. It may be, why don't we agree on X discovery? And then we'll have another, reach back out and see if you need a little different than the hours. Or sometimes they need the discovery to decide how they're going to proceed with the hearing. So it's almost a bifurcated process. Okay, let's take it through discovery. We'll have a conference, and then you're going to decide, do you want to do this on the papers? Do you want an evidentiary hearing? Maybe you need better information to understand what your process is going to be.
Right.
I think if it's the party's process and it should be fluid and follow it, those are just options. Not in every case, but sometimes it works.
Well, obviously,
these are all-
the preliminary hearing is a hot topic for everyone on this
We
panel.
could have just done
Entire hour and a
this.
half on this.
We could take the entire time
Well,
doing
to
it.
that point, how long is your normal preliminary hearing? I know there's some arbitrators that
Oh, yes.
do a robust preliminary hearing that lasts an hour and a half to 2
I mean, I've
hours.
seen it.
I think some of you in this panel might know who I'm talking about.
Yeah.
But
3 hours
3
is
hours.
the longest I've ever experienced
what's the on average, an hour?
An hour.
as a member of a
If it's
tribunal.
complex, half if it's less.
Does mediation ever come up? Or not?
Yes.
Like,
yeah.
how often? Is it?
I think most of us probably at this point try to include it in the schedule.
And how do you bring it up? You just say,
Just bring it up.
I ask a question. Have you mediated it?
okay.
And it just sort of opens the door,
Right.
and they can respond, they've done it and it was unsuccessful, or they're not interested, or maybe they'd like to consider it in conjunction with or parallel with the ongoing arbitration. But I ask as a question.
But David, as you know, there's some arbitrators that are strongly against that. And I've seen that on the blog that I do, that they don't think arbitrators should be talking about mediation at all.
Yeah, no, I hear you. And I wouldn't encourage, I don't go beyond that. That's why I say I ask it as a question. I want to know if it's occurred or if that's something they want, but I don't get involved in it.
Got it.
I don't get involved in it unless they tell me that they want to do it. And then that may implicate the schedule.
And to that point of it implicating the schedule, if they do say they want to do mediation and you have the conundrum of having an excessive amount of discovery that folks would want, I've had many conversations where we will stage the discovery so that they can get to the mediation, and then we will come back and have another procedural hearing to determine what the next steps are if mediation doesn't succeed.
And that's the kind of thing I think is good to preview at that first preliminary conference, that we're going to ideally include a window for negotiation or mediation, something that you will do outside of the purview of the tribunal at a time that makes sense, at an inflection point after the documentary evidence has come in or some other time. If it's a very complex case, you might even put 2 windows in, but they are in parallel to the case proceeding. It's not an interruption of the case, and it's not something that the tribunal is involved with. Of course, if the tribunal at some point is notified, like, we need a pause, we're negotiating, then, you take that issue at the time. But I think previewing at the beginning is at the very first conference is important. I think most people do it. And sometimes, the response is, we did that already, and timing is everything with mediation. And so, still putting in a window for it and saying that you want to reserve the right to add that to the schedule as we, finesse the dates and work the schedule out is helpful, because then nobody's asking to negotiate because of anything other than the schedule, really having that in, on the calendar.
I think we could devote a full hour, in fact, I'm sure we could, to how to address mediation in the context of a preliminary hearing. That said, I do want to make an overall comment in addition to the excellent points that have been made by the three panelists. And that is, we talk a lot about counsel preparing for the preliminary hearing. It's equally important that the arbitrator prepare for the preliminary hearing. You have to bear in mind that this is the first opportunity that the parties have to evaluate you. And they are going to be doing that during the preliminary hearing. They're going to try to assess whether this is somebody they can push around. On the other hand, they're going to try to assess whether this is an arbitrator who's going to work with them and make this a collaborative exercise, which obviously is the preferred method. And one of the ways that you can do that is make sure that you have read everything in the web file, because that will enable you not only to understand the case and to make some comments during the preliminary hearing evidencing that you understand the case, but also to spot issues which you may want to discuss during the preliminary hearing. You may spot an arbitrability issue, which Steve and I are going to talk about later. And there's nothing more satisfying to the parties in terms of establishing your credibility than seeing an arbitrator who's fully prepared.
Okay, we have to move on to the next panel in about a minute or so, but one quick final question for this panel. Do you like, if you're using an institution, do you like to have the case manager on? Does that help or not on the preliminary hearing?
My own view is yes, it's good to have the case manager involved. To what degree, at least aware of what's going on.
That they're there, okay.
Yeah. And there are issues that can come up, like where's the hearing going to take place,
Scheduling,
and
you know,
scheduling, and
Right.
right.
They can check that there's
Just check.
availability for a hearing during the week of, whatever, 2027. They can,
Sure.
But I think it's asking a lot for the case manager to stay on for
The whole thing, no.
3 hours.
I think for the
you have
first,
one of those.
yeah. David, your thoughts?
Yeah, the case managers are very busy with a variety of things. I mean, when I'm running or conducting a preliminary conference, the case manager may be on with her, unseen, and doesn't participate at all. So it's not that they're participating in the conference. It's good to have them apprised of what's going on and aware of what's going on. And yes, when it comes to say, oh, we're going to have it scheduled at the AAA's offices, he or she can check that out maybe on the spot. So it can be helpful, but if it's not their, best use of their time, I wouldn't insist upon it.
Well, this was a great panel, guys. Thank you very much. Now we're going to move on to our next panel, but first I have to do the CLE code for those that are getting CLEs. The first CLE letter is H. H for happy or hero. And if I can ask the gentleman in the back, how many people do we have in the virtual world? 81, thank you. So welcome to the virtual world too. Okay, our next topic.
Can they hear?
Oh, yes.
Yeah, how's
Can
the
you see if they're
audio?
speaking? If you cannot hear in the virtual world, we're trying to lean into our microphones. Just email the tech person.
Chat.
Okay, the chat area. Okay, I don't see it up front, so I would do it otherwise. Okay, our next topic, great topic. Leslie and I actually were in Atlanta on Friday talking about commercial finance and arbitration, and we actually incidentally touched on the topic of AI and it kind of derailed the topic. So a lot of people want to talk about this topic right now, especially AAA. I admit that. So their topic, Jen and Leslie, are going to talk about AI practices for the arbitrator. So take it away, guys.
Good evening. So our talk is split up into two different sections. The first section, which I will cover, will touch on the technology and the different opportunities for arbitrators and counsel to a certain extent to utilize AI and also a definition. And then Leslie's going to cover the ethical considerations for arbitrators and the use of AI. So AI is an amorphous term. Artificial intelligence has been with us for a very long time, but now we are talking about it because of something called generative AI. Those are your chat GPTs, your Copilot from Microsoft, your Claude from Anthropic, amongst other products. Those products are what you would call they're generative AI, and what that means is that they utilize data sets to train the model to output information that it looks a lot like information that a human would output. And with the use of these products, we've seen a fair amount of case law in recent years, since 2022 when ChatGPT launched, wherein counsel has used generative AI, particularly ChatGPT, because it was the leader. It may no longer be. And that generative AI has created what looks like case law, what sounds like case law, and which is an absolute and utter hallucination. So with the use of these products, what I oftentimes say to folks is, you have to get comfortable with them, right? Everyone in this room that I'm looking at, except for the 2 students in the back, or 3 students, had to make a change from looking up the law in books, the cases and the statutes, to online, Westlaw and Lexis, to the internet, to smartphones, little computers you carry with you. And now we're at this new burgeoning subject, which is probably far more reaching than the internet ever was. It's changing every day quickly. So what I say to folks is, you have to spend time learning what this product can offer to you, and you also have to check its outputs. The output is only as good as the input. So for arbitrators, what we have available to us are the chat GPTs, are the Claudes, are the Copilots, and what we can utilize them for is taking large amounts of data that is not confidential, Leslie will talk about this, that's not confidential, and timelining it, taking voluminous amounts of case law and asking for an output that summarizes, asking to go further in any particular case with a prompt that speaks specifically to issues that are before you in that arbitration, so that it'll pull out. Ask in your prompt things like, one of the things that I do is I take a case, I upload the case, and I say, okay, I'd like you to break out all the different issues that were before the court, and then what is the analysis for each one of the issues? Provide me a table of cases from the cases cited by the court, and give me page references back to the case for each proposition that you are laying out. So then I can go back to the case myself when I'm, writing an award and say, wait a second, okay, my output says X, and I can go back and cross-reference because I trust my output because I like my prompt, but I verify because I know that any number of these generative AI products can hallucinate. Now, other things that we can do as arbitrators utilizing generative AI is what I had mentioned before, which is timelining. Sometimes you have a case that has a tremendous amount of moving parts. And if you start early on with the case and you start plugging in just the non-confidential information, but things that you need to keep in a sequence, you can ask it to create a document for you. You can ask it to create charts, graphs. You can ask it to create, today I asked it to do, I'll tell you, today I asked as I was walking out, I said, well, let me run on to ChatGPT and to Claude and ask it to produce for me what are the primed legal programs that utilize AI, and what are the prime programs that can be used by arbitrators. I asked each one of the products to do so for both of those prompts, and it gave me outputs. Now, I already know what the applications are that are available, the Harveys, the Spell Book. You know, Legora is a new product which has a damn sexy ad with Jude Law in it. It is unbelievable. You would have no idea what they're selling, but that's a new one, just launched. Go look up the commercial for that. GC AI. These are all different products that are available to the legal profession, and some of them have applications for arbitrators as well. But most of the concerns that everyone should have as arbitrators in utilizing AI is to know three things. One is to make sure that the program that you're using is, what type of program is it? Is it a closed loop that is, for example, a product that the AAA arbitrators have available to them, like ClearBrief, where you can upload a whole bunch of documents like transcripts from depositions, hearing briefs, et cetera, and ask it to do a certain amount of services for you and produce outputs. That is a closed loop system. It does not train on the information that you upload. And once you're done with utilizing the service, it forgets what you have put on, what you have fed it. Versus open loops. Now, open loop trains on what you are putting in as data. And that is problematic for us as arbitrators. That's even problematic for the legal profession to use just an open AI system and upload documents and kind of hope for the best. Not a good thing. But there is a mechanism, and there are different versions. Let me start with, there are different versions of open loop AI programs like a chat or a Claude, where you can actually, and I've done this, I put in a prompt and I said, is there a way that you don't train on what I am giving you? And sure enough, there is. You have to go into the settings. It's like, of course, buried, but it gave me an output that told me how I can turn off in my pro version, my paid version of ChatGPT and Claude to utilize those services and not have my data train the model. Now, I'm going to get to a caveat on this. That does not necessarily mean that the information that I input remains confidential. It is only when you get to an enterprise level of any of these open source, open AI programs that you can get that level of customization where it is actually, in effect, a closed loop. So be cautious when you're paying for Chat Pro or Claude Pro and putting that prompt in like I did to shut down the training. That should not give you any confidence that the model is not, that what you are outputting could be confidential information. It cannot. The last point is, and it is the one thing that is very interesting to me, is that every day when I utilize a generative AI program, it's different. Its outputs are different from a week ago, a month ago, a year ago, because the data sets that are being fed to these programs are so much more sophisticated because they're learning new things. And also the folks who have created these products have learned a lot from the users of the products of what they need. So, and the last thing is, for all the folks that are concerned about folks losing jobs, the folks who have lost jobs have new jobs, and those jobs are to create the data sets to train the generative AI program. So low-level lawyers, paralegals, and folks in other industries are creating those data sets based upon questions from the providers, the Anthropics, the OpenAI, Microsoft. They're buying that data to train their models. So that's why I'm saying that every day the models are getting better.
Perfect. So pivoting over, let's talk about some ethical rules here. And this is a burgeoning and growing field. So there are tools out there for canons, and when I get a minute or two at the end, I'm just going to highlight briefly some of the model rules that govern lawyers in general, but some of these that I'm focusing on first are targeted to us as arbitrators. So the AAAI-CDR has guidance on arbitrators' use of AI. The CIARB has a guideline. The ABA has a formal opinion 512 that was issued in June of 2024. Vienna International Arbitral Center, and I could go on, but you're starting to see in the last couple of years ethical rules, models, and canons coming out specifically addressed to arbitrators. So Canon 5 is independent decision-making. We are required to keep complete control over our decision-making process. As arbitrators, unless you're on a tripartite panel, it's you alone that are making this decision. Now, AI could be used, as we've seen it in the news, improperly so, to make decisions, render decisions, et cetera. If you are using AI for, let's say, research, because again, we have our boundaries on what we truly can do as research, or evidence analysis, we have to make sure that the decisions are still ours. So Jen talked about ClearBrief. That really is a tool for arbitrators' AI. It's not intended to make decisions. It is a compilation and organization of data, timeline, and you're reading and checking it anyway, assuming you are using it. But it's not going, oh, and by the way, claimant wins, respondent loses, and here's the 16 reasons why. That's not what it's supposed to do. If you're using it to promote efficiency, organize, create tables, timelines, and charts, then it's not taking away from who you are as an arbitrator. If properly used in a closed system with all the security protocols and disclosure. Canon 1, the tools are assistants. They're additive, but they're not always right. Depending on how they're used, depending on what they do, AI systems are designed to please. The reason half the time you get a hallucination is not only because, first of all, garbage in and garbage out, but you get it because it wants to give you a result. So if you make up something, and a couple of years ago, Steve did this, and I never remember what it was, made up some, rule that existed, and AI said, great, let me help Steve, and came up with an answer, sounded lovely, it never existed, but it wants to be helpful. Your job, no different than when you read papers, render a decision, and go back, is to be accurate, to be correct, to make sure that what has come out of whatever you are doing is appropriate. So if you use it in whatever capacity you appropriately use it, even to create a timeline, maybe it saved you some time. You got to go back and make sure it's right. You have to make sure that if it said X, Y, and Z happened on that date, ideally it's given you the site, you go back and you check it, because if not, it's on you. For 2 seconds, when all these lawyers that keep complaining, we were just at the ABA and I was at a judges initiative meeting, and they were talking about sanctioning all these lawyers and they're blaming it on AI. And my response is, that's like blaming it on Westlaw. I mean, if I search Westlaw, which is a form of AI, and 3 cases pop out and I cite those cases, I know from Westlaw the cases exist. But if I've read the blurb and the heading, and that's not what the case says because the person that put it in didn't get it right, or it was searching and my prompts were wrong, that's on me as a lawyer. And there needs to be responsibility taken when this happens. Disclosure. This is where we get into, there is some debate on this, but the general belief is, I think, that if you're using an AI tool, parties need to know that. They need to know in what capacity you are doing it. Now, we've talked about whether or not if you used, well, again, we don't research as arbitrators. We do read the cases that are assigned, that parties cite to us. We read cases within cases. We may check to see if those are good cases. I mean, we have the right to do that. But if you are using this in some part of your decision-making, you may need to be transparent and let the parties know what tools are in play, because it's their data, their confidentiality. And one of the things that I'm starting to see, and I'm sure others are, and I don't think it's unique to arbitration, but in the protective orders and confidentiality orders, there are provisions now being included. You're disclosing this information between two parties in discovery. They're limiting what they can do with it. I think it's appropriate. If you are going to utilize AI, claimant and respondent, is it a closed system? Is it a protected system? It's popping up, and I think it needs to pop up. And that
Can I
gets,
stop you 1
sure,
second and tie into the first panel?
should be covered.
So in your preliminary hearing, I have taken, and this is just my opinion, I have taken up the issue of AI. And I ask, and that is a new point, a new bullet point in my note that goes out to council beforehand about, let's discuss how, because people are using it. So I'm not going to make a belief, I'm not going to behave as if nobody's using it. So how will we use it? How would you like to limit the use of it? How would you like to expand the use of it? And we have a discussion. I've had probably about 3 or 4 preliminary hearings in the last 4 months where we've really spent probably about 15, 20 minutes talking about the use of AI, my use, theirs.
Do you
And I-
get pushback from the parties on that? Like one side saying we shouldn't be using it, the other side saying, no, I use it all the time.
What I'm finding is that the side that wishes to use AI is more sophisticated in the use of AI and is typically from big law. So they have a whole host and suite of
Options, yeah.
options. And then I might have a mid-sized firm on the other side, and they are intimidated by the use of AI because they don't have those resources. So we have to negotiate and how to get some sort of parity. And then also my use of AI. I disclose clear brief, and I also disclose, like, look, at the end of the day, I might summarize the cases in ways that are different outside of this. Do you have an issue with that? And I get buy-in, and if somebody says no, that is their right.
So let me ask a question, maybe playing a little bit of a devil's advocate.
Mhm.
So let's say counsel is, in preparing its briefs, is using AI in its research. Why do we care if they use an associate to do the research or they use AI to do the research? Obviously, they have to check and make sure that the research is accurate. They take ultimate responsibility for it. They're putting their names on it. But if they're using AI as a tool, as you would use an associate as a tool or as an individual doing the research, why do we care if that's a tool that they're using?
Two
There's
issues.
2 issues
It's-
on that.
Okay.
Correct.
Is it
Go
the same
ahead.
too?
So it gets it, thank you,
It
you're
is,
peaking.
probably.
Confidentiality is next,
There you
because
go.
here is the difference. If I assign Richard to do my research as an associate, not that he'd ever do that for me, he works for me. He's not go running down the hall. If Dana does it, and for argument's sake, doesn't know that it should be in a closed system, and now she's put it out there, that party's just breached the confidentiality of the process because it's out in the ether. It has nothing to do with whether it's arbitration or not arbitration. There are cases coming out about blowing attorney-client privilege. You've agreed to a confidentiality agreement and you put it on an open system. The private facts of the arbitration and the arguments are now out there. It's very different. So do I care if they're using it in a closed system? I don't know that I care as an arbitrator. But the party that's disclosing documents and now hasn't asked for a confidentiality order has the right to say, if you are going to use it, you are representing that you are putting in protocols, no different than the cybersecurity provisions we put in our preliminary hearing orders that require them to be mindful that they're not using a laptop that's on Wi-Fi and putting data and financial data out there. It's to protect the integrity of the exchange of information within a process that's intended to be confidential. So I don't personally care as an arbitrator if they've used it or not used it. That's on them. I care if somebody's blowing confidentiality. And that's the piece of it that I think triggers the concern.
Right, but so it sounds like, if I'm understanding you, that it's putting the documents in there. But if you're just doing research as you would do research, regular research,
Separate issue.
you're just looking up a law,
That's a
you're
separate
looking up
issue.
a legal issue, and you're
We're not
using
talking about
AI to
that.
help you,
We're not
then does that
talking
matter?
about that.
No, we're not talking about that.
Using Westlaw, using Lexis, using any of the legal research programs to conduct legal research, we're not talking about that. What we're talking about is the production of the document that is being delivered to the tribunal, the pre-hearing briefs, the post-hearing briefs, witness statements, et cetera. Folks do not understand necessarily how all of this works. And if we have a confidentiality, well, if we have a protective order in place, great. But 90% of the time, folks don't even ask for a protective order. And they certainly have an expectation that in this confidential process, that the information that they are disclosing to their counterparty is not going to end up training ChatGPT.
I'm going to add one twist to what I just said. So a lot of the courts, we're all seeing certification. The judge is asking for a certification that you don't use AI, or if you have, how you've checked it. So given now, judges and their clerks in their chambers, because I've been one, can research. The parties give briefs in and we can go off and do whatever we want. We are much more limited here. So here's a theoretical concern. So if the parties don't tell me they're using AI and they do their research, and I only get research from A and B, and that's my universe of the world, and they've given me hallucinated cases, query, how do I know that if they haven't? Now, again, I'm supposed to read the case, so I guess I pick it up that way. But maybe there is a fine line at some point where we do have a concern. I don't know that we're there yet. The judges have very different concerns because they want you to represent so that if you scooch that up, they are going to sanction you.
So
Did you have something? Oh,
I mean,
okay.
I think that, number one, there's an adversary. So if somebody cites
Theoretically, if you have a real adversary, you're right.
in real arbitration, and also,
Correct.
and the hallucinations are really going away.
Yeah,
Yes, they are.
as it learns,
Yes, they are.
100%, it absolutely does.
Yep.
A couple of other things, just briefly, is, and this is more general. So just keep in mind that we have model rules, ABA model rules. This does not just apply to arbitrators. In fact, there's an open question about, these are geared towards lawyers. You have ABA Rule 1.1. You have an obligation to be competent. That means that you need to be able to work in today's world. And if you are not up on this technology and you are not current on the law and you are handling cases, you may not be meeting your requirement to be a competent lawyer across the board. Confidentiality shows up there as well. Communication with clients, ABA Rule 1.4, you do have an obligation to discuss with your client what you're doing. Now, this is not my arbitrator hat, this is just the lawyer hat, and talking about what you're using, what you're not using, getting client buy-in. So there's a lot of things that people need to really look at, both depending on which hat they're wearing, and really understand what you're doing, because the biggest risk comes from not understanding the world as it's moving, and it's moving fast, and misstepping in a way that puts your client in a compromised position.
We gotta move to the next topic for you, make a final
No,
comment.
I'm having a hard time following why this is particularly relevant for what arbitrators do, because I've been of the view that arbitrators should rely on the advocacy of the parties, assuming there's integrity to the advocacy, and should not be doing their own research.
Well,
Should not be.
but
should
it's not
be-
just research.
should not necessarily be reorganizing the record in a way that the arbitrator thinks would be useful, rather than having the parties do it that way for them. I just don't get it. I mean, I totally get it with respect to counsel and their obligations and how useful these tools can be. But I don't get why arbitrators need to master the technology, AI technology, and become masters of it, and then police the parties in their use of it.
Well, again, so two things. You don't necessarily, as an arbitrator, have to become a master of it if you are not going to use it. I'm just suggesting to you, and I'm not advocating
Why
for
would an arbitrator use it?
Because
I
they
don't
are.
understand it.
But Richard, they are
We gotta move on
using
to our
it.
next topic. We can
That's your
talk all
choice
night
not
on
to, what
AI.
other people do.
Just one quick question for the group. Everyone, just raise your hand. Who does not use AI for arbitration cases? Three, okay, very good point. Wow.
It depends, it
Just
well,
part of the
depends on
table.
which part you're talking
Okay.
about.
Our next, before we go, thank you, guys, that was
We're
great.
obsessed with the preliminary conference.
Yes.
That was terrific, thank you.
And by the way, in my notes was a comment about using AI, talking about AI or not in the preliminary conference. And when we discussed it as a as a panel, the three of us, the consensus was that there's no reason to raise it. I mean, we don't ask the parties if they're using Westlaw.
I think Richard wanted to be on the AI
Yeah,
panel.
on the AI panel. And then as
He
a
does it
last.
next year.
Yeah, and as a last
we're
plug
going.
for
Okay,
folks who really want to understand how AI as a technology works and also how in the English-speaking nations, AI is being addressed in arbitration and in the law, you can read my latest article, which is coming out in the next, I guess, what volume is this? Volume 19, number 1 of 2026 in the New York State Dispute Resolution Lawyer.
Okay, now our next CLE code, we have to move on to our next and final topic. The next CLE code is B. B for birthday or boy. Okay, B. The first one was H for happy. I think you guys know where I'm going with this one. Okay, so the last group is Rich and Steve, the conundrum of arbitral jurisdiction and arbitrability. And I want to thank Steve. He just flew in from Madrid earlier today, so thank you for making it. But gentlemen, Rich and
Great.
Steve.
Thanks. I'm going to start off and I'm going to pass it over to Rich shortly. We called this arbitrability and arbitral jurisdiction. Are they the same thing? Are they different? Let's talk about what the terms actually mean, and then we'll move on to what the law is in the U.S. About these issues. The rest of the world talks about arbitrability as, is this dispute capable of being resolved by arbitration under the law of that country? So in most of the world, employment disputes, consumer disputes are not arbitrable. And so you say it's a non-arbitrable dispute. When they talk about jurisdiction is, did the parties agree to arbitrate this dispute? And that's usually that's referred to as arbitral jurisdiction. The U.S. Supreme Court, in its infinite knowledge, has merged the two and basically uses arbitral jurisdiction. They call it arbitrability. So we're going to use them interchangeably, but I wanted to explain that that's not exactly the way the rest of the world sees it. So these issues in the U.S., they're broken down into essentially three categories. One is contract formation. So did the parties actually agree to arbitrate? Classic example, that's a forgery. I never signed that. That's a formation issue. Validity, that is, an unconscionable agreement. Might be imagine an agreement with your Microsoft license that says Bill Gates will be your arbitrator in any dispute you have with Microsoft, or there are many other arbitrability with contracts, many other adhesion issues with with consumer contracts, et cetera. If you agree to have a bot decide your case rather than a human being, that's probably not a valid arbitration agreement and would not be enforced by a court. You can do it, and if you paid voluntarily, it's fine. But the statutes talk about the arbitrators as being human beings. Section 7 of the FAA talks about appearing before them, and it says you can't even do it remotely because you have to actually be in the same physical space with the arbitrator. The arbitrator's a bot. They're not. They're in the cloud. They're not with you in the same room. So those are examples of validity. Scope is the last one, which is we have a carve out. Usually, very often you see all disputes arising out of or relating to this agreement. That's a broad clause, but you could say in an IP space, but not infringement of my patent or not validity of my patent. So then you're going to have a scope issue. Now, what's important to understand is that both courts and arbitrators have the authority to decide arbitrability or arbitral jurisdiction questions. And the Supreme Court in first options says that the courts have the primary authority. So the courts can decide it on the front end under Section 3 of the FAA to stay a litigation in favor of arbitration. They can enjoin an arbitration, or they can compel an arbitration. Or they can do it on the back end, such as in the first options case where the Kaplans came and said, look, I never agreed to arbitrate. The arbitrators ruled against them, and the Supreme Court said, you're entitled to de novo review. We're going to decide it because we have primary jurisdiction. What the court said essentially in dicta in that case, which has now created this conundrum that we're talking about, is, well, the parties can agree to arbitrate arbitrability just like they can agree to arbitrate the merits. So if they do that, then the courts have secondary authority and they have to defer to the arbitrator's decision on jurisdiction. But to do that, they have to do it by clear and unmistakable evidence. And so now, so the Supreme Court saw this again when Rent-A-Center, some sort of warehousing company or something like that, they actually put in their contract with their customers, and I'm quoting, "The arbitrator and not any federal, state, or local court or agency shall have exclusive authority to resolve any dispute relating to the interpretation, applicability, enforceability, or formation of this agreement, including but not limited to that all or any part of this agreement is void or voidable." So in that case, the court says, we really have no role. You've done that. The conundrum comes from cases that say, well, you don't have to go that far. If you just incorporate the AAA rules that say that the arbitrators have the authority to determine their own jurisdiction, you've done that. But they already did that. The rules don't say anything more than what the arbitrators, the power they already had. Because remember, in first options, the arbitrators determined their own jurisdiction in the first instance. They didn't need a rule to tell them that they can do that. They did that, and they still have secondary authority because the court came in and said you didn't, just merely showing up before the arbitrators and arguing arbitrability is not agreeing to arbitrate arbitrability. Now you can see why there's a confusion, because the lower courts have been saying that this incorporation of rules is enough. The Supreme Court says it has to be clear and unmistakable evidence. And the Supreme Court has ducked this issue for, the first option is 30 years old. They've been ducking this issue for at least 10 or 20 years. Most cases now are, you have to assume there's been a delegation if you're arbitrating under institutional rules or the UNCITRAL rules or any rules, because all rules actually say that. So the cases that maybe come before you as counsel or as arbitrator where there's no delegation is the issue of formation. As a forgery, or there was a condition preceding to the agreement even to spring into effect, and it is a therefore it's a formation issue. And the Supreme Court said in Granite Rock that formation is for the courts have primary authority. You really can't delegate formation issues because if you never had a contract, you're putting the cart before the horse, right? So what happens when you have a formation issue and it's brought before you as an arbitrator? My view is you decide it. You don't worry about the fact that the court's going to have de novo review afterwards. You just do your best. And if the court disagrees with you, then the court disagrees with you. What if you're counsel? Well, you have a right to go and enjoin the arbitration if you're the respondent. You might have the right. One of the problems with having the whole arbitration go forward and then the court having to second guess you and give you a de novo review at the end is you might have wasted all of years of arbitrating. So you might want to have a court compel arbitration on the front end. You may say, look, arbitrators, you hold off. I'm going to get a court to compel, and then that decision will be determined on the front end, and we don't have to worry about wasting time in the arbitration. The problem with that is there's case law saying you can't compel a party to arbitrate if they're already arbitrating. If they've shown up and they say we're here, but we have an objection to jurisdiction, no court's going to say I compel you to arbitrate, and I'm going to determine that issue because you can't compel somebody to do what they're already doing. So that's where you are as counsel. If you can, as a respondent, you probably should try to enjoin it. Or if you're claimant and the respondent is there, you're kind of stuck. Becomes a little more complicated when you're talking about non-signatories. It's a formation issue. So I never agreed to anything. I didn't sign anything. I'm not a signatory. What am I doing here? Then what is the court or an arbitrator or counsel to do? For that, we're going to hear from Rich.
Thank you, Steve. You all should be forgiven if your eyes are glossing over at these issues. Because, most of what we do as arbitrators is apply common law principles under a given jurisdiction's law, particular state law specified in the contract, and apply the administrative provider's rules. In this case, let's say the AAA commercial arbitration rules. And I think most arbitrators are comfortable with that. They're comfortable reading the rules and applying them, and they're comfortable applying common law principles that they need to bring to a particular case. However, what Steve just addressed in 6 or 7 minutes is one of the aspects of the law of arbitration. There is a law of arbitration. And the two issues, and I'd be curious if Steve agrees with me, the two issues that I think are most complicated under the law of arbitration are this issue of arbitrability and the issue of whether third parties can be subpoenaed to testify in an arbitration. The courts are all over the lot on those issues, and the Supreme Court has studiously avoided weighing in for the most part on those issues. So I'm going to spend just 5 minutes or so talking about the issue of non-signatories, which is also quite complicated. So if you're an arbitrator and one party is alleging that party Y is guilty of all kinds of dastardly conduct, but the problem is that party Y did not sign an arbitration agreement. And we all know that arbitration is the party's process and that one cannot be compelled to arbitrate if one has not agreed to do so. That's the general principle. But there are exceptions. And to my knowledge, there are about 6. If you split up a couple of them, you might come up with 7 or 8. But I'm just going to go through some of those exceptions. Number 1, a court can stop a party from avoiding a contract's obligation to arbitrate if the party asserts a claim or a defense under the contract and that contract contains an arbitration clause. So it's one thing to be a non-signatory, but you can be stopped from objecting to the arbitration panel's jurisdiction over you depending upon your conduct. Second, incorporation by reference. Courts recognize that an arbitration agreement incorporated from one document into another, if the documents taken together manifest an intent to arbitrate disputes, is valid. It's a valid delegation of the obligation to arbitrate if you incorporate by reference that arbitration obligation. Assignment. A person taking on the rights and obligations of another party by assignment under a contract containing an arbitration clause is likely to be compelled to arbitrate under that contract. Agency. The party seeking to compel the principal to arbitrate can allege sufficient facts to demonstrate the agency relationship between the alleged principal and the signatory. Courts also find apparent agency based on the apparent authority of the agent to bind the principal. Third-party beneficiary obligations. A third-party beneficiary of a contract can be compelled to arbitrate. And then my favorite, and that is alter ego or veil piercing. And I had reason to apply this recently in a case for which I was the neutral. But if a claimant can allege facts to establish a prima facie case, not by a preponderance of the evidence demonstration, but a prima facie case that the respondent has, even though a non-signatory, has controlled or overcome all of the activities of a subsidiary, for example, or an affiliated company, then that party, even though it's a non-signatory, can be compelled to arbitrate. So the question is, who decides? So I've just given you in 5 minutes 6 or 7 different theories under which a non-signatory can be compelled to arbitrate. But who decides that? Going back to what Steve told you, it's generally speaking the court, because this is a formation issue. You can't really cite the rules that exist in the American Arbitration Association commercial arbitration set, because the non-signatory is not a party to the agreement that contains those rules. So by and large, it's up to the court to decide whether any of the exceptions apply such that a non-signatory can be compelled to arbitrate. But what happens if the parties bring that issue to the arbitrators? And I've had that happen several times. The parties say, the respondent says, I have an objection to arbitrability based upon the fact that I'm a non-signatory. and then you wait as the neutral, couple of seconds, 5 seconds, and you're waiting for that party to tell you, therefore I'm going to court. But that doesn't happen. They're looking to you to decide that issue. Can you decide it? Absolutely. So I'm going to ask Steve this question. You know that it's most appropriate that the court decide that issue because it goes to contract formation. And if that party that is a non-signatory says to you, we object, but then doesn't say anything about going to court, do you feel that the arbitrator has an obligation to tell that party, then you should go to court?
Absolutely not. I mean, that's giving legal advice. It may be it may be the smarter thing to do as counsel, and we talked about that earlier on other arbitrability questions, but they're here and they're saying, we're making a special appearance. We don't believe you have power over us, and here's why, and we're going to bifurcate this into a jurisdictional phase, and you decide it. The question is, did they agree to arbitrate arbitrability? Was that clear and unmistakable evidence? That's not your problem as an arbitrator. That's the review you're going to get after your award. So the Kaplans did that. We object, but we're not arbitrating. They didn't say we're not arbitrating arbitrability. They just merely argued arbitrability, and they were non-signatories, and they got de novo review, and that's fine. And I've heard arbitrators say, "Well, I don't want to be vacated." Well, that's not. Then you're in the wrong business if you're worried about making a decision. There is a wrinkle, though, Rich. We haven't discussed this, but it's a recent case about a year or maybe 2 years ago called Ellison. And there are many Ellison decisions because it's an arbitration. Yeah, it went off the rails in a lot of ways. And the law firms are being sued and all kinds of stuff. But the issue that's relevant to what we're doing, and I'm curious to your views on this, in that case, you have claimant against respondent A, who's a signatory, and respondent B, let's say they're a related company. Respondent B doesn't show up like Mr. and Mrs. Kaplan. They ignore the process. The claimant comes in with evidence to show alter ego or agency or all these other things, and B is nowhere to be heard from. The arbitrator went ahead and found and awarded against A and B. Judge Lyman set aside the award, saying the arbitrator had no business deciding that issue because the respondent didn't show up. And that incentivizes the respondent not to show up. And I don't think that's right. What do you think?
Yeah, I agree. I don't think that that is the appropriate decision. You know, this ties in with what Richard was talking about a few minutes ago, that he doesn't want to get involved in, advocating a position for one party or the other. He takes what the parties give him. And in this context, I think that means that if a party doesn't show up, well, there are rules about that. The AAA commercial arbitration rules provide that if a party doesn't show up, you can proceed in the absence of that party, provided that you make sure that it's been a fair process and so on and so forth. So if I were the judge in that case, I would have proceeded to affirm the grant of the relief, if assuming it was appropriate, against the non-appearing party.
Yeah, you might have been de novo review. There might have been any number of things, but to say he had no business deciding the case is a little weird. But to push back a little bit, maybe devil's advocate, the AAA rules talk about you don't take default judgments, but how you proceed it with a non-defending party. That presupposes that there's an arbitration agreement, and in the non-signatory context, there isn't one. So there was, everything is.
That's a good point.
Everything is cart before the horse in this thing, and you can go round and round.
Yeah.
And also, if I may ask, should the court have considered the reason for the non-appearance of respondent B? And how would the court even be able to know that? But what if there was a legitimate reason for respondent B not appearing in the arbitration?
Assume respondent B decided as a strategic matter not to show up, because if it showed up, then then the court might defer to the arbitrator's ruling on jurisdiction, and it doesn't want to run that risk. Let's assume that. I mean, it is. I mean, I'm no longer counseling clients, but I think if a client came to me and said, "I am respondent B, I never agreed to arbitrate, and I don't want the court to defer to the arbitrators on this, so I'm just going to ignore it." Is that a good strategy or not? I don't know. And in light of this decision, maybe it is.
What if respondent B didn't have the funds to defend the case? In other words, there was some kind of an understandable, if not
I mean, most times,
rational reason.
But that's, I mean, he's got a better reason saying I never agreed to arbitrate. The fact that I don't feel like paying a lawyer is generally not a good reason.
Ever a good reason.
So I know
Can
we have
ask
to
a
tie
question
things up.
Before you move on, there is this hypothetical about whether, well, the question was whether or not the arbitrator should say, you should go to court. Okay. Isn't the response, or isn't a response that would be appropriate? Well, are you submitting that question to me? Just asking the party? Just make the record that is being submitted?
Yes, by all means. I mean, that's what I did in the situation that I had most recently involving that precise situation where I
In other
was
words, are
waiting.
you talking to me? You know, it's like-
I was waiting for them to say, and therefore we're going to court. Didn't happen. And after I exhausted the possibility that they were going to make that statement, I said, okay, so do I understand correctly that you are submitting the issue to me? And if that's the case, let's talk about a process for doing that.
Right. But to go back to the non-appearing respondent B, you are the arbitrator. Now, you don't like to do your own research, but let's say you have your own knowledge, right? And you know about the Ellison decision. Let's assume it's affirmed by the Second Circuit, and you've got a claimant with a non-appearing, non-signatory respondent. Should you say, you know, courts are telling me not to go forward unless this person either appeared or has been compelled to arbitrate. You certainly can compel him because he hasn't shown up. You want my award? It might be ignored by a court, but if you get an order compelling arbitration, then you know I have jurisdiction, we go forward. Those are unanswered questions by Ellison, I think.
Would you do that in terms of explaining that you have an option of going to court without advising them to do so?
I don't know. I mean, that's kind of, you're crossing the line between being a neutral and giving legal advice. So I think it is a conundrum.
It is a conundrum.
Good ending.
Okay. Rich, final comment?
I would just say that we are very lucky to have Steve around, because whenever, at least speaking for myself, whenever I have a particularly difficult problem involving the law of arbitration, he's my first call.
Thank you.
I also call him too. Okay, before I thank our panelists, our wonderful panelists, and Peter in New York Law School, our final CLE letter is A, okay, A for Apple, or American Arbitration Association. So our letters are H, happy, B, birthday, and A, AAA. It's our centennial, so happy birthday to AAA. But I want to thank our wonderful panelists. Thank you so much. You guys were wonderful, as always. And Peter, thank you, hosting and arranging and everything, for letting us be here. So,
Same
thank
time next year.
Yep, thank you, audience.
Yeah,
Thank you all.
Fascinating.
That long opinion.
I know. It's